Dear Jonas, dear Marta, thank you for inviting me. This honor to be with you today in Budapest. This is new wonderful platform to meeting with children's rights. And for me as Nicholas, I think that is one of the best name to be the Ombudsman for children. So, how to protect children's rights today? The role of the Ombudsman for children. First, I would like to focus on the institution and the role of the Ombudsman for children in general and form the perspective of the authority granted by Polish legislation. Above all else, the Ombudsman for children has to be an independent children's rights institution, independent of the government or any other authorities. The interests of the Ombudsman often vary from the interest of the state, so his independence is crucial. The Ombudsman mandate should be set out in legislation to seal his freedom from any pressure. The Ombudsman for children has specific aims to achieve. First, promote full implementation of Convention of the Rights of the Child, CRC, influence law, policy and practice, by responding to governmental and other proposals and any actively proposing changes. Third, provide a channel for children's views and to encourage government and the public to give proper respect to children's views. And fourth, promote awareness of the human rights of children among children and adults. The above list is, of course, not completed. For example, it is the Polish approach that Ombudsman has a mandate to conduct investigations, respond to individual complaints, and initiate or support legal action on behalf of children. Ombudsman is in other countries do not usually have this wide authority. When I decide to join proceedings, very often I move to the court for hearing the child. I believe that where possible, we must really allow children to speak their mind, to tell us what they think and what they feel. Adults make the decisions, but decisions must be informed. We must bring together the theory of Article 12 of the CRC and practice of the courtroom. And this should be the task of the Ombudsman for children. Another important area of authority of the Polish Ombudsman for children is the control power. It is expressed in the Ombudsman's rights to check if proceeding or decision address the best interest of the child. For this purpose, using the legal instruments included in the Act of the Ombudsman for Children, the Ombudsman may, among other things, examine each case on the spot, even without notice, demand explanation or documents for public authorities, organizations, and institutions. The Ombudsman is also entitled to participate or initiate civil and administrative proceedings, like prosecutor as advocate for children, enter into proceedings in cases involving juvenile offenders, appeal against the judgment, participate in proceedings before the Constitutional Tribunal. This control power of the Ombudsman in the light of the Article 3 of CRC is a good tool to safeguard the best interest of the child in action undertaken by public or private social welfare institutions, courts, or administrative authorities. Another example of how the practice of my bureau serves the theory of the convention. Bekeeping in an independent position, the ombudsman takes the role of the child's advocate, who has in mind the child's well-being. In all action, I consider the best interest of the child and not parents or anyone else. Having the scope of mandate, the ombudsman may be a real stronghold for the United Nations Convention. These are some of the aspects regarding the role of ombudsman from my perspective. A perspective of many powers reaching as far as highest court instance. A very important area ombuds activity is promotion of the rights of the child. In fact, everything the ombudsman does promotes awareness of children's rights among children and adults. And this short film is one of our activity. This is in social media, this is in a few televisions in Poland, and this is for children. We should treat awareness-raising activities an especially important area of our work. We should produce information about children's rights, teach and educate. Reach children and adults with informations. Sometimes violations are caused by ignorance, not evil. The ombudsman has many ways to effect promotion of children's rights. One of them, simply talk to children and young people, meet with them. This is why I visit schools, many schools, every single week. I have few visits. I invite children to my office. I facilitate youth participation project. This leads us to children and young people's participation in public life, a key factor to modern approach supporting the involvement of children who will soon be adults and maker decisions. If we provide a channel for children's views, we can help children become some adults. We can support the practice of Article 13 CRC. I have been ombudsman for children since the end of the 2018, so I have last 1 year now. It is hard to believe that it's already been 4 years, time flies. Every day on my term, I came across new challenges. I learned how to overcome them. I see new horizons. I believe that the role of the ombudsman is to lead the way, set new standards, and look far ahead into the future. But we have very truly hard time, first COVID. This year, however, has brought extreme challenges. With the war in Ukraine, we came down again to most basic children's rights, like the rights to life. This year, the Ombudsman for Children, like every other institution, had to act fast to welcome the vast influx of minors, refugees, looking for safety away from the war zone. It has become clear that the interest of children from Ukraine must be put above all else. Their situation is hard to imagine. The Ombudsman for Children had to engage to the fullest extent in all possible areas of help. I have been monitoring the situation of children escaping from the war zone and cooperating with institutions to find best possible solutions. On my initiative is a 24/7 telephone helpline and online chat. This film is about it. It's a practice developed to meet the pressing needs of Ukrainian children coming to Poland. We started with this phone in 2020 when it was COVID, but this activity is very needed in this time. Through these helplines, psychological help is offered not only in Polish, but also in Ukrainian and Russian. by phone and by chat. In last year, 2021, we had 38,000 calls and 8,000 chat. Now, in 2022, from January to November, we had 42,000 calls and 11,000 chats. Our office and the helpline have now become first contact clinic for children in need of immediate assistance. It is so important to make it is possible for children to have immediate access to professional help. We offer psychological, pedagogical, and legal help also in Ukrainian. This initiative was just an answer to proceeding new need. We finally came to this general question: how to protect children's rights today? I think that first we must know the rights. We must spread in the idea and the knowledge as wide as possible. Second, we must know the tools, instruments, the mechanism of protection. We have to know how to use them. Third, we must see the violations and we must react. And finally, we have to work together to lift the standards higher. And this is platform in Budapest. I, as Polish Ombudsman for Children, have this special duty to carry on the work started long ago by such Poles like Ludwig Reichmann, originator and co-founder UNICEF, or Professor Tadeusz Smyczyński, author of the early draft on the UN Convention, or Polish United Nations Ambassador Eugeniusz Wisner, who is in 1978 proposed to the UN Human Rights Committee to adopt the conventions. Or last, Janusz Korczak, great educator, known for this revolutionary approach to children as people. I would like to leave you with this idea: children are people. Their rights are, in fact, human rights. The only difference is they need more protection from us. Thank you.
As you can see here, that my presentation title is General Aspects of Children's Rights. And I like to keep the time. So basically, I would like to give for you a short introduction after a summary on children's rights in canonical history, after canonical documents in protection of children's rights, and then some canonical penal protection of children and its different levels, canonical protection of children's family heritage, including their religious identity, and finally conclusion. So first of all, I would like to refer to Pius XI. It's a very interesting question, because during the last 24 hours, you have heard several references for the last 30 years, and particularly to John Paul II's initiative, which goes back to 1990, actually. But in Canada, we can find some references already by Pius XI, who in 1929, his Apostolic Constitution Divini Illius Magistri already emphasized the most important core idea, which was several times mentioned during the last that beside every Christian child or youth has a strict right to instruction in harmony with the teaching of the Church on the pillar and ground of truth, and according to the family. And I think it is some crucial thing that we are going back always to the family teaching, which was transforming to the educational system and other angles of the teaching possibilities. So let me talk about something on canon historical background. It's obvious that the children's rights did not appear in canon terminology until the 20th century. However, this does not mean that the children were not protected by canon law before that. Several times we can hear in the media that in the criminal law protection of violence against children, the term zero tolerance. This is a common expression nowadays, and as if it seems to us that is a novelty of the 21st century. However, when we examine canon law sources, we can see that it is not exactly true, because already from the middle of the 2nd century, we can find several documents in canonical legislation protect, on a general sense, something which we call nowadays, in modern expression, as human rights. Of course, protection of violation of the so-called sexual abuses, so-called delicta graviora, so the gravest delicts against children were already regulated from the middle of the 2nd century. Of course, not on that level what we have now. I have different references from the Decretum Gratiani. I don't want to take your time for the list, but in fact, you can see how the canonical regulation developed from the 2nd century until the current time. Also, there is a very important right which was also mentioned together with children already in the middle of the 3rd century, so one century later, and this is basically the family right to educate the children in order to learn the truth. So even the children have right to have education to learn and to know the truth, which was, of course, the original meaning in the 3rd century was some religious truth. But in that very time, the teaching were together, the secular teaching and also the religious teaching, and of course I don't want to mention the nice glass windows and the Cathedral of Chartres, when the moral education, the historical education, and definitely the religious education were together, is following those painted windows in the 14th century, what I mentioned. My next emphasized topic is canonical documents on protection of children's rights. And when I was composing this very short overview, I tried to focus not only the so-called greatest delicate, which happened several times in the past, and unfortunately is happening nowadays too, even the satellite regulation, but also other rights of what we have heard just recently, we have already in 1965 the so-called Gravissimo Educationis, which is the document of the Second Vatican Council, basically the guideline for education in the family, education from the kindergarten up to the university level, education within the society. So we can call in the 21st century terminology, this is the ongoing formation, an interactive ongoing formation of children. The second very important document is promulgated by the Congregation for Instituzione Cattolica, which was promulgated in 1988, and this is about religious education, of course, in the Catholic school. The third one, just a decade later, about the general education within family ends and on institutional level too. It was promulgated by the same Congregation for Education in 1997. And my fourth reference is an Instrumentum Laboris in 2014, which I will refer several times in my presentation, because this Instrumentum Laboris is prepared plan for children education and the so-called integrated education was defined in this document, and the whole way from 2014 until 2050 were planned in the document. It is, of course, you can see according to the date, it was already under Pope Francis pontificate. And of course, I should mention the recent reform of the Code of Canon Law by the Pashita Greg MP, which of course basically about the penal part of the Code of Canon Law, which part penalized every single act against the children's right. According to regarding the canonical penal law protection and the different levels, at the first place, I should mention the Code of Canon Law. Two very important fields. Of course, the first one is the one which is always mentioned when we are talking about the church education, and the church reacted very rapidly and hopefully more effectively to prevent sexual and educational abuses and penalizing of sexual and education abuses. I would like to emphasize that it's not only we are talking about not only sexual abuse, but educational abuses. Educational abuses, which is a particular term when the teacher is misusing that position, and the teacher is in general sense. So when we are talking about teacher is not, or educator can be within the school, but outside the school also. We know very well that was just mentioned the digitalized education, and it's very important when we are talking about the different educations. We are not talking only on the education of the children, but also the educations of the educator. The next level is other people and dicastery norms, what I have just listed regarding the from the Second Vatican Council until 2014. I think it was a very important step when the local bishop conferences started to implement the general and universal decisions of the church on the national level. And this implementation posed several guidelines on the special conditions of different countries. Of course, the conditions in Europe is different as compared with Central or Southern Africa. So when we are talking about the Bishop Conference decisions, we have to understand that the differences within the society and what is the needy in different situations. It was just to mention today the situation where which is very close to Hungary now, and it was just at the east border of the European Union. It means the Ukrainian situation when we receive children, also of course families and refugee children, and we should provide education, which we should provide that atmosphere which continue that ongoing formation of the children, what they have started at their native country, and of course it is responsibility of the state, it's responsibility for the different churches, this responsibility for cities, and for the responsibility of definitely on the family level too. So level of the local bishops and other ordinaries is also very important nowadays in canon law. Of course, it is a very low level in the canonical legislation, but in fact, the detailed prescriptions on the different types of institutes, their supervision and the operation office for the protection of the rights of children. It is very important. We can see also many different programs. These different programs are not only for children but for education. If I'm talking about not only the Central European situation, but even the U.S. situation. In U.S., since 2001, they have started every single diocese 30 hours program for the teachers, particularly focusing on children's rights, and anyone who starts the education or teaching, I mean, in school which run by the Catholic Church, he or she should complete this program, and always just after this program, they can start their work in the school. I think it's very important because it's always focusing on in the theological terminology, following Jean-Paul II wording, the so-called new humanism and integrate this education, which should serve the common good of the society, because the children is the future of the society. And it is very important that the children, even every single child has different talent, different opportunities. They could get the special education which can help to reach the highest level and the highest value of his or her own capability. And of course, the fifth level, and I think is also very important, the level of the concrete institution. So we can see several protocols around the whole world within the Catholic educational system, not only about the ongoing formation, what I have already mentioned, but several protocols, which protocols help to assist to the different orientation and those children who are arriving to the educational system with a different family and different religious and different social background. It is important to handle the education on the highest level, because we already heard about to reach the equality. Reach the equality, it means that the equal value, everything tried for the highest level of education, to learn what is the most important talent of the person, and to help to ensure every ability of the particular child. It is a real challenge of every single school, and basically this is the real challenge of the 21st century, and this is the fundamental change at the previous centuries, because we are focusing on the person and not just in the community, but on the particular person. So I would like to cite some of the main ideas of the mentioned documents. So about canonical protection of children's family heritage, including the religious identity. So the mentioned Human Education from 1965, Article 6, is underlining that parents who have the primary and inalienable right and duty to educate their children must enjoy true liberty in their choice of schools. Of course, we know that there was a time, and in 1965 was definitely that time, when many countries, and unfortunately still now, there are several countries where this free choice is impossible. Therefore, the education is again going back to the family, and the family will be the responsible in those countries for the best education for their children. And this is also very very challengeable, that the education within the family and education in the school could be in harmony. This sometimes is almost impossible to harmonize because it's a so-called double education. The 1988 document of the Congregation for Education from the Holy See is also about the religious freedom and the personal conscience of the individual students and their families must be respected, and this freedom is explicitly recognized by the church, which means that the church, according to the human rights, explicitly recognize the freedom of every single child in the society, in the formation, in the institutional education of the education system, including the Catholic educational system. So when I'm talking about Catholic educational system and freedom, I'm talking about that within the Catholic educational system, those who are not Catholic, and the majority in many countries within the Catholic education system cannot Catholic, they should have the freedom to follow the family heritage of their religion. The 1997 document, what I cited before, point out that those initiatives which are ignoring the principle of religious freedom of the citizens to educate their children according to their own traditional belief can destroy many unchangeable values. I would like to point out this also, because when I'm talking about religious freedom, it is not only about religious freedom. It is the core of the family. The family gives in the well, if the family is working well, it gives the 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 icon for the children, and if the other formation is against that that structure, that truth, what is the explanation from the family, is always making a difficulty for the children to follow the education. Well, I'm saying this, I'm not talking only about the catechetical education, but I'm talking about the history, even the natural sciences. If the information is arriving in different interpretation, of course, is a challenge for a different age that they can understand what is belonging to the religious background from the family, what they receive from the family, and what is the other interpretation which doesn't has that religious background. Just think about the ethical level, the moral level. Morality is always lays on the religious conviction. So different religious convictions can have different moral basis, and it is a challengeable question nowadays when we like to make an integrated education for our children within our education system. And finally, the 2014 document, which emphasizes psychological, social, cultural, religious diversity of children, should not be hidden, denied, but considered as an opportunity and gift. Those who are most in difficulty, poorest, most fragile, most in need, should be at the focus of the school's attention, of the society's attention, and of course those who are helping to the family in the interactivity with the children, because this final document is emphasizing in every single chapter that the interactivity with the children is also very important, because they not only must told, but they must heard by the educators, by the people who are responsible to protect the children rights. So as conclusion, it is clear that the protection of children's rights is not limited to the prevention and sanctioning of the greatest delicts. The different rights of children have been and are interpreted by the canon law on the basis of the Holy Scriptures, of course, and the so-called Great Mission Commandment of Jesus Christ, which gave opportunity to the church already in the 3rd century to talking about to have right to get to know the truth, even for children, and it is accordance with the divine law. This has generated very specific canonical rules and institutional frameworks in the different epochs of history. Ensuring the observance of the law has also required the protection of children's rights through penal law. This system required further substantial reinforcement in the 20th and 21st centuries, which led to the foundation of the Pontifical Commission for Protection of Minors in 2014 in the Vatican. It was a crucial step of Pope Francis when he established this institutionalized commission, which is responsible to deal with every different angle of children's rights, and setting up of similar organizations at Bishop Conference level and also the diocese level. Thank you very much for your attention.
Thank you very much for introduction. And of course, big thank to the organizers, Marta. I will address in my presentation just some points of the child marriages, because if we could speak about just this topic for more days. Namely, throughout history, till the 20th century, child marriages were common in most parts of the world, since the average life expectancy was in past only 40 to 45 years. In some cultures, for example, in ancient Egypt was 35, in more going back to the history was just 17 years. So the child marriages were the faster way to reproduce. Girls were usually married as soon as they reached puberty or even earlier. But in the 20th century, at the beginning of the 20th century, perceptions of marriage and childhood has changed. Namely, in the 20th century, countries started to developing. Women began to receive education, voting rights, and also other rights. Women also entered in the workforce, since the industrial development was very rapid. Therefore, also women become their improvement of their economic living conditions. Also, their life expectancy become longer, because also medicine made a huge development at that time. Therefore, the practice of child weddings was called into the question. Child marriages began to disappear in the developed economics, but on the other side of the world, they are still common in many countries. For example, several international conventions are committed to eradicate child marriage by giving the definition, or to oblige the states. The states have the responsibilities for protecting children for marriage, defining a minimum age of marriage, and requiring free and full consent in any marital decision. On the other side, we have also several international documents that are aiming to reach the goal that the marriage of a girl and a boy before the age of 18 is defined as violation of the child's human rights. But it is very interesting that the yesterday and today many times mentioned Children's Rights Convention does not specifically mention child marriage. It was adopted in 1989, but this convention obligates state parties to take measures to abolish all traditional practices prejudicial to the health of children. And of course, we all knew that the child marriage is not necessary in the benefit of the child. What about child marriages today? We already mentioned that many states tried all international documents and follow it also by the state's regulation, try to abolish the possibility of child marriages. But as we can see, the child marriages are still very present. In some countries, here are listed some countries with the highest rates of the child marriages before the age of 18, and that is the standpoint 2015. And we can see that, for example, in the Niger, 76% of children have been married before the age of 18 years. And for example, there's also Chad, 68% of children. But we have to stress, we can go back to my first slide. There was mentioned that there was need to reproduce. Namely, if we compare Chad as an African state with Japan, which is the modern state with the highest, or the average population has the highest level in the Japan. That means that is the oldest population. On the other side, the Chad belongs to the countries with the lowest average of the population. The average of population is 16 years. So we can see that could be one of the reasons. On the other side, we have also India. India made huge steps in the way to forbid the child marriages, but there are still many parts, especially rural parts, where the 50% of, especially the girls, are married before the age of 18 years. But we have to mention also that, for example, on the other side we have United States. There is still 1% of the children under the age of 18 are also married before the 18 years. But what are the reasons for child marriages? I will name just two mostly cited. Poverty. Marrying of the daughter can mean one person less to be fed, clothed, or educate. And we know that in some cultures a bride price also exists, namely when the bride's parents will receive payment for their child, girl, they can use this money also for other family or other children. And we know also that the younger girls will reach higher bride price because they have more years for childbearing. Sad, but it's true. And we have also very deeply rooted tradition, especially in the Africa states. Child marriage is namely deeply embedded in some cultural traditions. It is viewed as a normal and a reasonable practice. Girls' role in society is to, as already mentioned, to bear children and raise a family, not, for example, education, like in our society. Early marriage will also prevent pregnancy out of wedlock. We know that if the girl will be raped, that is not her fault, but if she is under the age and become pregnant, they will see that is girl's fault. The girls could be abandoned, could be stoned, could be killed. And so the young early marriage could be also seen as the protection for the girl. And if a girl is no longer virgin, she is seen also as unsuitable for marriage. But what are the consequences related to the child marriages? Child marriages usually deprive the female child of educational rights, leading to the loss of financial independence of the child. Child brides are also faced with marital rapes, domestic violence, sexual abuse. They are also not mature enough to protest against such situation, and are also not independent enough to escape for this hard family or marital situation. We know if the girl is married, she will leave the school. That is also connected with the highest percentage of the illiteracy, which also lower educational attainment, and thus a lack of opportunities for both personal and professional development in the future. And of course, we should not forget the health problems. I remember I have 3 children. Giving birth to each child was very painful, long in time, and I could not imagine to give the birth as a 12 years old girl, which has happened, or even less. We know that I think it is the 9 years, the youngest mother in the world. So you could imagine what is happening to these girls. And of course, health problems are also related to the stillbirth, premature birth, sexual transmitted diseases, and etc. But we spoke before about the Africa, about the India, about other parts of the world. Slovenia is part of our world. Let's take a look in the Slovenian regulation. In Slovenia, adopted in 2017 new family code, so the marriageable years is 18. That is bound to the legal presumption that the child will become mature with 18 years, and the child is able to make the independent decisions, and that is based on the legal presumption, and the child will gain with 18 years the legal capacity. But we still have the exemption that the child could marry older than 15 years. Of course, in this case, it's necessary to obtain the court authorization. I found some statistics, but I see the problem in these statistics because there it is covering just the period between 15 and 20 years. But we could say that 20 is also very young to marry today, but we can see that it's declining. So it's very good, but after the family code was adopted, we can see that there are still, from my side, still brides which are at least younger than 20 years, and there are 62 such girls. I didn't get any information what was between 15 and 18, so I'm sorry, but it could be a good comparison. For example, if the child in Slovenia, it's the same for the girl and for the boy, want to get married, they need authorization, court authorization. The child has to file the application to the court, and the court will evaluate this application. The court will prove these 4 conditions. The child must be older than 15 age. The court will try to find if there are justified grounds. That is the legal standard. That means that the court in every single case has to find what is justified grounds. Years ago, it was of course if the girl was pregnant. But today in Slovenia, there is equal rights for the children born in wedlock or born outside wedlock. And in Slovenia, the rate of children born outside wedlock is quite very high, 58%. So I think there is not so much more present. Maybe in some families, it's still very important that the girl, if the girl is pregnant, should marry, but usually not anymore in Slovenia. The court should find out if the child is physical and mental mature. For example, I think there's no possibility to marry just for the reason of pure love, because we know if the girl is 15 or 16, they could be very deeply in love, so that should not be the reason. They should find out if there is maturity. And of course, the child should understand the meaning and consequences of the marriage. So the court will invite the child, the future spouse, parents. Parents can express their opinion, but the decision is on the court. And of course, the Center for Social Work will be asked for the opinion. And the end, the court, depends from the case to case, will make decision if the authorization should be given or not. So, what about child marriages tomorrow? We already mentioned that, of course, some international documents wanted to eradicate the child marriages, and one of such latest is also Sustainable Development Goals, which call for the global action to end child rights violation and harmful practice by 2030. Is that possible? I think we have just 7 years, and we can see that so many children are still not just in the child marriages, they're still in the forced marriages or arranged marriages. So we have not much time to do. I think it's not realistic, but if we proceed and if we can save any girl or even woman from child marriage, forced marriage, arranged marriage, we can see this, that succession. And on the other side, it's quite a long way to eradicate this. There are still necessary to arrange the help and support for those who want to leave or annul their marriages, are married, but they want to come out of such marriages, and also for those who make the decision to remain in the marriage. One of that possibility is, of course, education. So the education is good weapon to fight also against the child marriages. And let's go to Slovenia. As already mentioned, in 2017, my opinion, Slovenia missed good opportunity to put the border for the marriage at the 18 years. As already some other countries made such decisions, for example, Denmark, Finland, and Netherlands. In Slovenia, we have still that 15, but with the exemption, 18, but the exemption 15 years. But, yes, child marriages are not just formal unions. There are also included informal unions. So if we would raise the age limitation to the 18, that means that just formal unions will be possible to prevent. But we also should know that in many communities or families, for example, in Slovenia, there are present Roma. Roma are not usually getting married, but they are living in such communities from very early age of the children. So at the end, we can see we have a lot to do worldwide, but there are many states, I know that also Hungary and other national legislation present here still have this exemption possibility. So let's start with us, then we will go further. Thank you very much.
To consider very briefly a few elements about how the COVID-19 pandemic and the lockdown has been affected the child justice system in the recent years, and above all, which kind of evolution we might have seen. And I will share directly entirely. I think it's better for you, right? So in the recent years, we have been working on a global campaign on accelerate release of children in detention during the COVID-19 pandemic. This campaign has won the World Justice Award last year, and allow us to release children, hundreds of children from detention in all over the world, and to train thousands of professionals to maintain the justice even during the lockdown. So we developed a set of operational guidelines for professionals, for security forces, as we believe that the first contact with the justice system is extremely important. And there was a lot of consideration, remember, around curfew, etc. the role of social workers and social workforce, or can you continue implementing alternative to deprivation of liberty, community-based sanction, etc., in a lockdown context? And of course, we develop guidelines for legal professionals, so lawyers, judges, magistrates, and how could we maintain justice, fair trial, and court proceeding during the COVID. While we were doing those reports, what we found very interesting is there was a new tendency of adopting virtual tools to justice. So we developed this new research, which is digital justice for children, and is supported by the pro bono department of Baker McKenzie. And we did a set of around 40 interviews of judges and magistrates, and specialized for children, some from Supreme Court, to see the evolution of the justice system all over the world. And from before the COVID, during the pandemic, and after. And what we found is that the system, you know, sometimes we consider the justice system as this big, let's say, elephant, mammoth, on difficult to move, not very reactive, not always in phase with the society. But what we found with the COVID pandemic is that, at the contrary, there was a lot of development to maintain justice and to adapt new practices and new rules. So we found basically two main models. The first one is a model of respecting the right of the child to be present physically in their trial, in its trial. So that's the case of country like, for instance, the Netherlands. And Ton, if you are in the room, you will be able to answer more questions later on about the Netherlands. But what we heard is that Netherlands tried to secure and develop more protective measures so kids could come back to the court, you know, with those plastic walls, etc., to avoid the contagion of the virus. Other countries decided to use digital technologies. So there was a case, for instance, in Mexico, where it started in Yucatan, in Merida, and then the good practice has been developed in the rest of states. In Bangladesh, where at the end of the pandemic, or at the end of the lockdown, let's say, because the pandemic is still around, 90% of the cases has been dealt by virtual hearing. Or in Europe, UK, or in North America, United States, etc. So we saw that the system tried to innovate and find quick solution. From there, our main issue was to consider if the justice system had the time to ensure some fundamental right guarantee and procedural safeguards for children in contact with the justice system in this virtual component. So by organizing this study, we found three main areas where digital tools are used. The first one, that was true outside and inside the justice system, is the access to education. We all know how that was during the lockdown and how children has been developing their learning sessions through computers and other platforms. So that has been used a lot in deprivation of liberty. The fact to maintain the contact as well by digital tools. All of that, in a certain way, is positive. If we keep an hybrid perspective, you know, we can't just do online, and human presence is extremely useful, in particular when you speak about the family, and the contact with the family is extremely important for the development of the child. Another aspect where justice system has been trying to use a digital mechanism is through everything regarding inspection, monitoring, complaint mechanism, etc. And that has shown very quickly the limits. It's very difficult to maintain the control or the monitor, or to monitor deprivation of liberty at distance. The last one, which is a point of interest for us today, is the issue of access to justice through in court system, and how and the development of virtual court system all over the world. So as I was saying, we noticed that the system evolved very recently, very quickly due to this extraordinary context of lockdown. But we might need to remember that before even the pandemic, there were some elements which was calling for an evolution of justice system. Unfortunately, perhaps not for the good reason. The first one is the context of funding crisis of the legal system, which was more or less true all over the planet. And more recently, what we found is that this, let's say, misguided idea of techno-solutionism, so that you can solve any problem with a computer, and as you can imagine, is not true. We found that digital tools can be extremely useful if they are used in a kind of hybrid way. So there is certainly opportunity to use digitalization of some part of the justice system and not all of it. And in any case, we need to remember that what is leading the justice action is the best interest of the child and the child-centered approach. And this might not have been true everywhere. If you dig a little bit and you check the different reforms after the COVID, there is a tendency to see that the evolution of the justice system toward a more digital justice system has been done in the best interest of the criminal justice professional rather than the children sometimes. And then the child interest itself has been sometimes sidelined. So you all know that we have, and you've been speaking about that for the last 1 day and a half, there is some key principle around fair trial for children. I will not come back to all of them, but I think what is important here is to focus on some elements. The first one, as I was saying, the best interests of the child and the child-centered approach. Another element which I think is important to keep a fair trial is that international rules and standards are asking us to focus on the primacy of diversionary measures to judicial proceeding, and I will add, of alternative measures to deprivation of liberty. Sometimes we have the effect that by making a system more efficient through those digital tools, we are losing this perspective of focusing on diversionary measures. Another element is certainly the detention as a measure of last resort. And unfortunately, several research, and one of them in the United States from the Gold Center, have shown that children who've been through the virtual court hearing might end up with higher risk to get a deprivation, a measure of deprivation of liberty rather than rather than a child in an in-person court proceeding. So there is a direct effect from the proceeding on the sentencing. And I think that is very important to keep that in mind because it changed, of course, the life of children. At European level, we all know about the child-friendly justice guidelines with very important 9 principles on age-appropriate, speedy, diligent, focus on the needs of the child, the due process, which is extremely important, the private and family life, etc. All of that is true in a personal hearing, but should be guaranteed during as well a virtual court proceeding. So they cannot be subject to any exception of derogation, which is challenging in some elements. For instance, respecting the right to privacy, to private and life on the digital world, you know, and the GDPR, the database, it's something to be considered and to, you know, we might have some question there about where is the recording, who is taking into account the the archive, etc. So during the last World Congress, Terre with its partner of the Global Initiative on Justice with Children organized each 3 to 4 years World Congress on Justice with Children. We had a specific session last year in November in which participate Ursula Kilkelly from Cork University, and she mentioned a study she'd done with Nessa Lynch from Wellington University in New Zealand, where they interviewed children going through this process of virtual court. And there was a lot of very interesting findings, but there is 3 elements that I wanted to bring you today to consider. The first one is that children who've been through a virtual court hearing, they did not really have the sense that they were involved at all in their own proceeding, in their own court proceeding. There was like a distance with what was happening. In another case, some other kids did not really understand the proceeding themselves, and the technology frustrated them. And then, and it's all linked to their effective participation in the proceeding that was stopped. And very interestingly, on some other part, and that's the positive, we always need to bring the both side of the coins. On the positive aspect, some children found that it was less, they were less afraid speaking in front of a computer rather than going in an adversarial courtroom. So, we can't really be ideologically against those evolution, but what we need to do is to think, where is the child best interest? So is where we started to work on a program of research regarding safeguarding measures for children in virtual court. And we actually launched a call for experts. So if some of you are interested in this topic and wanted to follow up of this discussion with us, we are working with several experts on producing challenge paper and policy brief on this issue. But what we found mainly is there is a need to promote procedural safeguard for children in virtual court. First is to some elements, there will be much more, but some element that I wanted to insist with you. The first one is the role of legal aid and the role of the lawyer in virtual court. And then how the child could be in contact with the lawyer while is having his trial at the same time. So, we need to think about those alternative channels. The other elements is to support the child technologically. So we need intermediaries. We can't just ask a child to connect in front of the computer and then not having any support. Another element that I found extremely important is the data protection. The child could be in a court, in a room. For instance, the audience could be at the police station, but we don't know if someone else is illegally, let's say, recording the session as well. So there is a lot of elements regarding data protection and privacy. And linked to that, the safe environment. We need to be sure that the child will not get the influence from the parents, from the police, or from anybody else who are not visible on screen. And then I think sometimes it's difficult to go against the evolution, but we need to give to the evolution of the justice system the right direction, or at least the one we want. And certainly a reflection has to be done on how could we incorporate digitalization of justice, virtual court, virtual hearing, into the justice system as it is nowadays towards a more hybrid approach. So for instance, the first contact with a judge could be in person, but we can imagine that several follow-up can be online once the connection has been set. So in conclusion, and I wanted to be brief because I know that you have a very big day today, but I'm really happy to answer questions if you have some. But in conclusion, I wanted to bring you to the fact that if we can't fight against the recent evolution of the justice system, we can certainly work together as civil society to impose some procedural safeguard for children in that aspect in virtual hearing, but as well in other aspects on digitalization, such as the use of artificial intelligence in legal aid, in profiling, etc. So I will finish with that, and I hope I will that will bring you some elements of food for thought to think after during the coffee breaks about the future of justice for children. Thank you very much.
Good morning, everyone. I am Agnieszka Tomczewska. I am very happy to be here, and I would like to thank the organizers for invitation or for such great initiative. The rights of the child is very important, and actually, I am deputy director in the Department of Family and Juvenile, and I supervise the team, the group of very excellent people dealing with the child rights, family law, and also right of the victim crimes. And I would like to tell about our legislative initiative to prevent of domestic violence. As I said, protection of children and families is a priority of Ministry of Justice, and Ministry of Justice drafted the act adopted on 30th of April 2020 and entered into force on 30 November 2020. And the act introduced, among others, the solution allowing to immediately separate the perpetrator of domestic violence from his victim. On the basis of new provision, a police officer or military police officer has the right to issue an order against the perpetrator of domestic violence who possesses a threat to the life or health of a person affected by violence to immediately move out from the jointly occupied residential unit and its immediate surroundings. It is named order, or to prohibit him from homing near to the residential unit and its immediate surroundings. It is a prohibition. And the order and the prohibition might be applied jointly and are valid for 14 days. The order or prohibition shall be immediately enforceable. In order to determine whether the arrest or order or prohibition is justified, a police officer shall assess the risk of imminent danger to human life or health separately for adults and children, and they use a special questionnaire for the assessment of the risk or threat to human life or health. And I would like to add that this questionnaire was prepared with the consultation with the psychologist, and they are separately for children and for adults. As regards adults, they include such criteria as age of a child, the scale of aggression, the manner of behavior of the perpetrator, and the disabilities. And following the order or prohibition, an abusive householder member shall receive a list of alternative accommodation for him to stay in case no place is available to him. The services are obliged to check if the abusive household members does not breach the rules of that order or ban. Violation of order or prohibition is an offense, and whenever a prohibition order has been issued and it affects children, the police must report it to the family court, which verifies the child's situation, and the court must act to ensure the child is safe. The victim of violence is informed about the possibility of receiving support from the Justice Fund, such as legal aid, financial or psychological support. A victim of violence may request prolongation of the police order and prohibition by the court, then the perpetrator of domestic violence must not return to their dwelling place after 14 days. Such requests should be decided upon within 3 days. A victim of violence may always, even in absence of the police order or prohibition, file a free of charge application at the court to put the violent person under the obligation to move out from their common household and its immediate surroundings. The court shall issue the decision on the case within 1 month from the date of the victim's request. Sorry. And also I would like to describe our action that we undertook to guarantee the proper implementation of the Act, namely during the vacatio legis period, interdisciplinary training for the ministry service members was introduced, of course in cooperation with the police and military police, and also first contact person acting within the justice funds were trained, and the numbers are that in that training more than 28,000 police officers participated, military soldiers also more than 1,000, and more than 500 first contact persons. We also prepare a practical commentary for the military service members, as it contains essential information for the police and military police officers. Also, we prepare webinars for probation officers, title of that webinar, Together Against Violence, and more than 500 court probation officers participate in that training. And also, Ministry of Justice prepared a special website dedicated to the victims of violence, Get Free from Violence. And now it's in Polish and in Ukrainian language. And since the beginning of the law, so during last 2 years, about 8,600 police orders have been issued. After the success of first version of Anti-Violence Acts, we decided to improve some new protector measures, and now it is under the parliamentary work, the second version of this act, and it stipulates a ban for domestic violence offender to approach the victim of the violence, and it stipulates a certain distance in meters, a ban for a domestic violence offender to contact the victim, and a ban for a domestic violence offender to enter and stay in school, education, care, or artistic facility or a place of work or regular performance of victim of domestic violence. And the mechanism of issuing that new protective measures is the same as before. So immediate protection orders will be issued by a police officer, or military service officer for the 14 days. Protection of orders will be issued by the courts and remain in force until modified or discharged. And the novelty is that whenever it is intended to modify or discharge the decision on the protection orders, the court shall consider the circumstances concerning the victims and the perpetrator of domestic violence, in particular, the history and the results of action taken and documented under the blue card procedure. It is a special procedure for the domestic violence, but it's not a court procedure. The second is participation in a corrective and educational program for the perpetrators of the domestic violence, and psychological and therapeutic program for those persons and its result. And the next criterion is participation in other forms of intervention, such as addiction treatment therapies and their results. As before, an interdisciplinary training for the military service will be introduced in cooperation with the police and the military service. And the training will include a section dedicated to the psychology and the part focused on the cultural aspect of domestic violence. The practical commentary for the military service will also be prepared. And a part of this component anti-violence, we also introduced the friendly justice system for children and also people with disabilities. So the provision introducing a procedure to hear out person with mental or developmental disorders. The draft act stipulates that direct obligation for the supportive and alternative measure communication being in use in compliance with the way the person communicates with the environment. For purpose of the provision, the purpose of the provision is to increase protection of persons who, because of their condition, are more vulnerable to violence. And also the drafted acts include a principle of instructing children and vulnerable persons in a friendly way. Consequently, we prepare the instructions, explanations, and information notice regarding the hearing written in so-called plain and easy to understand language. The instructions for victims, witness, will also contain illustration. So it ends my presentation, and thank you for your attention.
Dear ladies and gentlemen, dear colleagues, it is a great pleasure and a great honor for me to speak in front of such distinguished audience. But before I start, I would like to proudly announce that this presentation was prepared within the framework of an excellent international research project that is the Polish-Hungarian research platform that has been coordinated by the Institute of Justice in Warsaw. And here I would like to take the opportunity to thank the Institute of Justice for that possibility. So today I would like to speak about the international parental child abduction, or in the language of international documents, about the wrongful removal and the wrongful retention of children, which refers to such situations when one of the parents takes the child to another country or returns the child there without the consent of the other parent. Since 1970s, much has been done on the international level to prevent such situations from happening and to deal with them. And a landmark step in that regard was the adoption of the Hague Convention on Civil Aspects of International Child Abduction in 1918, which I will speak about later on. Unfortunately, these steps have not prevented international parental child abductions from happening. On the contrary, it is a still growing phenomenon. And according to the latest available statistics published by the Hague Conference on Private International Law, annually, globally, approximately 3,000 children are involved in cross-border child abduction, or more precisely, in the return applications. And the average age of an abducted child is under 7 years old. So we are speaking about very small children. To help you visualize this number of 3,000 children abducted annually, I have put here the picture of the Hungarian State Opera House with a capacity of 1,300. That means that annually, the number of annually abducted children is twice the capacity of this main hall, which makes quite a crowd, doesn't it? So as you can see, the international parental child abduction is a real and is a huge challenge for the international community. It is a challenge which requires, from one hand, legal steps to deal with a legal problem, but on the other hand, which requires taking care of the human face behind the child abduction, that is the protection of small children. So first, a few words about the legal solution. That is the 1980 Hague Convention, which I mentioned earlier, it provides for a mandatory return mechanism according to which a requested state needs to order the return of an abducted child to the country where the child had his or her normal residence before the abduction, without deciding on custody, because that will be the task of the court in the child's home country. Such mechanism is based on the general presumption that the fast return of abducted children to their familiar environment is in their best interest, and that it will have a deterrent effect, preventing potential abductors. Okay, so it's my turn to play with the presenter. The Hague Convention provides for some exceptions to the obligatory return of the child. Some of them refer to the child's individual situation, but as a rule, the return of the child shall be ordered expeditiously, and under the Hague Convention, otherwise there is no time to conduct an in-depth examination of the child's family situation, because as a general rule, the return proceedings shall last no longer than 6 weeks. So that was the legal solution, and you may ask, do we need to better protect the child's best interests if we already have such a internationally recognized and widely supported legal mechanism in the Hague Convention, which is designed according to the preamble of the convention to protect children internationally from the harmful effects of their abduction. Well, I believe there are at least two reasons for concern regarding the protection of the best interests of the child under the Hague Convention. One is related to the legal status of the child in the convention, and the other one to the changed demographic situation of the international parental child abduction. So, what seems to be obvious now, that a child is an individual subject of rights, is basically the achievement of the Convention on the Rights of the Child, adopted in 1989. As we already heard today from Professor Slivhard's presentation, the CRC was a game changer and changed the way we look at children, the way we take children, whether we take them seriously or not. And it wasn't so obvious at the time of the drafting of the Hague Convention, which represents more traditional, less individual approach to children's rights protection. It seeks to protect more collective interests of children as a group by providing zero tolerance for abduction and deterring child abduction in general. It leaves rather limited space and time for the consideration of the individual situation of a child. But at the same time, since 1989, we have the principle of the best interest of the child laid down in Article 3 of the CRC, according to which in all actions concerning children, whether taken by public or private institutions, authorities, the best interest of the child shall be a primary consideration. And it is already generally accepted today that assessing and determining the child's best interest shall be carried out on a case-by-case basis. That means individually for each child. Let me quote here the Committee on the Rights of the Child, which in one of the general comments explained that determining what is in the best interest of the child should start with an assessment of the specific circumstances that make the child unique. So, as you can see, there's a difference of approaches in the two documents. On one hand, the requirement to to promptly order the return of the child stemming from the Hague Convention, and on the other hand, the requirement to treat the child individually, stemming from the Convention on the Rights of the Child, gives rise to several concerns and challenges surrounding the implementation application of the 1980 Hague Convention. The other reason for concern, as I mentioned, is connected to the new or changed demographic context of international child abduction. In around the 1980s, when the Hague Convention was being drafted, a typical case of cross-border child abduction was that of a father abducting a child from the mother. So the application of the Hague return mechanism led to the obligatory return of the child to the mother. Nowadays, we have quite the opposite situation. In over 70% of cases, mothers are the abducting parents. And that means that nowadays the application of the Hague return mechanism leads to the return of the child to the father. I don't have to tell you that such situation may be very dangerous for the child's welfare. It raises several concerns. And let me mention here only two consequences. So one is the possible separation of a child from the mother, and the other one is the risk of multiple relocations of the child. If the child first gets abducted, then the child is returned to the home country. Then the child might face another relocation, this time a lawful relocation, if during the litigation custody, mother is granted custody rights and she's taking the child again abroad. So we may ask, what would be the solution for better protecting child's best interest in face of such serious concerns surrounding the Hague Convention? I've already tried to suggest an answer in the title of my presentation, so I think we should consider the international family mediation. I think that we all instinctively know what mediation is. In a nutshell, it is a process conducted by an impartial and qualified mediator who has no power to decide, but who helps the parties, here the parents, to resolve their problem themselves. In family mediation, the role of a mediator is to help the parents to separate their interests from the interests of their child and to refocus on the child. As such, family mediation has several benefits in general, but in the context of the Hague return proceedings, it may have some additional value, which is connected to the fact that it may help to mitigate some of the concerns that I mentioned earlier. So in mediation, unlike in the judicial proceedings, parents can better focus on the individual situation of their child. I believe that the assessment of the best interest of the child can be easier and more accurate in mediation because it is such assessment is being carried out by the persons who know the child the best. So by the child's children with the help of mediator. So ideally, during mediation, parents may come to a tailor-made agreement that takes into account the needs of the child, the views of the child, and also that way the best interest of the child. And the court where the return application is pending does not have to order the return of the child to the left-behind parent if during mediation the left-behind parent agrees to the child staying with the abducting parent. As we said, before, typically with the mother. So that way, it may help to avoid the separation of the child from the mother, and it also helps to avoid the risk of multiple relocation. But otherwise, if parents agree on the child coming back to the left-behind parent and to the country of normal residence, in mediation, parents may discuss, for example, the conditions of the return of the child and maybe also of the mother to the place of habitual residence. And that's also something very important for the well-being of the child. So to sum up, cross-border family mediation can be a tool to protect the best interests of an individual child, as opposed to quite technical approach presented in the Hague Convention. It brings in children's rights approach into the convention. But here I would like to emphasize that the Hague Convention and the cross-border family mediation are not mutually exclusive, and on the contrary, they can and maybe they should go hand in hand, because it is believed that the best interests of the child is best protected when international family mediation is complementing judicial return proceedings. Why? Because the combination of a widely recognized international legal mechanism with the benefits of mediation allows to address the legal aspects of the international child abduction in the context of an individual family situation. It is sometimes said that the private international law prefers clear-cut cases over balancing. And I believe that international family mediation complementing judicial return proceedings can result in a clear-cut case, but with the benefits of balancing interests for the sake of the protection of the best interests of the child. Thank you very much.
Thank you very much. I'm honored to be here to present the outcomes of my work in front of such a distinguished audience. For that honor, I have to thank the Mádl Ferenc Institute and Ms. Marta, who made my appearance possible. Today, I'm going to talk about the deprivation of parental rights, whether it is a safety net for children or for parents. Having in mind that you are all experts in the field of children's rights, I will just briefly remind you of the provision of the Convention of the Rights of the Child regarding protection of violence. So I just put those provisions on the slide, but state parties shall take all appropriate legislative, administrative, social and educational measures to protect the child from all forms of physical or mental violence, injury of abuse, neglect or negligent treatment, maltreatment or exploitation, including sexual abuse, violent care of parents, legal guardians, or any other person who has the care of the child. Those measures also include effective procedures from those who have the care of the child, including at the end judicial involvement, which is in the focus of my research. However, the question of what the violence is was not left open, having in mind that different judicial systems would interpret the legal terms in different ways. The Committee of the Right of the Child adopted General Comment number 13 2015 in 2011 and defined the key terms regarding the violence. When I heard and found this heard of and read that general comment, I thought, well, we all know what the violence is. Why did they have to make this general comment and at the first place, and at the second place, why is it so long? However, when I saw what really fell under the scope of the violence, I was really surprised, to say so, how broad this term is. So, firstly, the violence is neglect or negligent treatment. For example, physical neglect, failure to protect a child from harm, including through lack of supervision or failure to provide the child with basic necessity, including adequate food, shelter, clothing, and basic medical care. Well, we will all say that it is something that we expected. Psychological or emotional neglect, including lack of any emotional support and love, chronic inattention to the child, caregivers being psychologically unavailable by overlooking young children's clues and signs, exposure to the intimate partner violence, drug or alcohol abuse, neglect of children's physical or mental health, then educational neglect, failure to comply with law required caregivers to secure their children's education through attendance at school or otherwise, and abandoned. So those terms, neglect or negligent treatment, is something that we all expected to see in this general comment, I believe. As for mental violence, it includes all forms of persistent harmful interaction with the child, for example, conveying to children that they are worthless, unloved, unwanted, endangered, or only of value in meeting another's needs. So when you say to the child, if you love me, you would do this or that, which is the sentence typically referring to emotional relationships between adults, but it is something that is also heard between parents and child, we can ask ourselves whether it is a form of mental violence. Then scaring, terrorizing and threatening, exploiting and corrupting, spurning and rejecting, isolating, ignoring, and favoritism. So when you say, let him do it, he is younger, he is a boy, he is so or so, you put the child in the situation that he or she feels some kind of mental violence, denying emotional responsiveness, neglecting mental health, medical and educational needs, then insult, name-calling, humiliation, bullying, ridiculing, and hurting a child's feelings. For example, when my boy climbed into the tree, I wanted to reward him, and I said to him, "Oh, great, I'm so proud, you're like a monkey." And he was so insulted, and he said that he is not an animal, so I had to apologize the whole day and explain that I said that as a compliment, but I didn't do that again. Exposure to domestic violence. And the next one is very interesting. Placement in solitary confinement, isolation, or humiliating or degrading conditions of detention. In the broader explanation, in this general comment, it also refers to the punishment of isolation. For example, in Serbia, the debate about corporal punishment is ongoing, and as one of the acceptable, even desirable forms of punishment, instead of corporal punishment, is isolation children in the other room, in some other room, in order to think over its behavior and get back later when he or she has to apologize or something like that. But as for the comment, it's also the form of the violence. Psychological bullying, referring to cyberbullying especially, then physical violence, which includes all corporal punishment and all other forms of torture, cruel, inhuman, or degrading treatment or punishment. For example, violence among children, self-harm, and some form of harmful practice, which includes but are not limited to corporal punishment and other cruel or degrading forms of punishment, then female genital mutilation, amputation, binding, scaring, burning, and branding. For example, the cases in which children are left without a leg or the arm in order to look and behave as the children with disabilities in order to beg for money, violent and degrading initiation rates, force feeding of girls. But nowadays I think that not only force feedings, but also not giving the food to the young girls in order to become models or actresses, virginity testing. Then forced marriages and early marriages, as Professor Kraljić spoke to previously, honor crimes, retribution acts of violence, then accusations of witchcraft, and uvulectomy and teeth extractions. So the violence against children is recognized also in the concluding observation on the combined periodical report of Serbia. Those data are from 2017, and these combined concluding observations shows the high number of reported cases of violence against children, then the inhuman or degrading treatment experienced by children, particularly children with disabilities living in institutional care homes, then child marriages, corporal punishment, and etc. So the question is, what does Serbia offer, or what did Serbia do? The procedure for deprivation of parental rights and parent abusing rights or grossly neglecting duties that are a comprising part of parental rights may be fully deprived of parental right. So here is said what is actually thought to be the abusing or neglecting behavior. So parent is abusing rights that are comprising parental rights, and he and she physically, sexually, or psychologically abuse the child. If he or she abused the child by forcing the child to access labor or endanger the moral health or education of child, of labor that is prohibited by law, then accusement of child to indulge in bad propensities and other manner maliciously abuses the rights of the child. However, here is the list of the acts that fell under the scope of grossly negligent behavior. So abandon of the child, not taking the care of the child, not supporting the child, or maintaining personal contact, then not creating the condition for common life, and in another manner, grossly violence of the rights of the child. But and who can initiate the procedure? child, other parent, public prosecutor, and guardianship authority. There are some special provisions regarding to the procedure of deprivation for parental rights, rules of special procedure, then urgency, and the role of the guardianship authorities, as well as the special special provisions regarding the participation rights of the child. However, I saved the best for the end, to say so. I conducted the research regarding the case of deprivation of parental rights in the Basic Court of Niš from 2005 to 2010. It's a bit old research, but there is no any later research for Serbia, neither for Niš, neither for other cities. And I wanted to see what was the causes for deprivation of parental rights. In this period, annually, the social care center was reported between 35 and 70 cases of violence against children annually. So in 5 years, it would be maybe 250 cases of domestic violence against children. However, in 5 years period, there were only 12 cases of deprivation of parental rights in Basic Court Niš. Five of them, this blue piece of apply, goes to the abandon of the children. Those are parents who didn't want to take their always a child with a disability after the birth, and they wanted to left it in the hospital after the delivery. So those children actually couldn't go to the adoption procedure, neither in some institution without the formal deprivation of parental rights. So to say so, this is not the deprivation of parental rights, but to the deliberation of parents of their parental duties. For those children, having in mind that they are unwanted, this is the best solution, because they have the opportunity to be put in some other family more willing to take care of them, but it is not seen as a measure of punishment, as a sanction for parents who inappropriately and violently behave towards their children, but as the way to free from their unwanted children. The 5 other cases are gross neglect, but again, for example, for letting a minor girl to get married twice. Actually, it's not really the marriage, the form of marriage, but letting her to left the primary family and go and get married, and some other not so violent acts of parents. Then one case is really what we see as the abuse of parental rights with all of the harmful practice over the child, corporal punishment, which led to the hospital detention and so on. And the 12th case is something which is dispute between parents. What I wanted to say is that the deprivation of parental rights as a measure of sanction and punishment of the parents who commit the violence toward a child is actually doesn't fulfill its its goal, because it seems not to be the safety net for children, but for the safety net for the parents who get to be so rude and to say to get rid of their children. For that purpose, I think that Serbia has to find the more efficient and better way to protect those children, and to see more serious the concluding observations that it received from the Committee from the Rights of the Child, as well as this general comment that, which shows that not everything which we thought is allowed is really allowed. Thank you very much for your attention, and I have to apologize to the other participants, because I have to leave immediately over the transportation I have. Thank you.
And she will hold a presentation on children's rights to remedy. Thank you very much for the invitation, and thanks for your attention. We are a little bit behind the schedule, but I'm very happy that all of you are still here. So, together with the organizers, we agreed on that I will speak about children's rights to remedy as an essential element of protection. So in 2014, UNICEF Hungarian Commission had a research. Around 1,000 children participated, and it turned out that every second child regards slapping on the face not as physical violence. So even if the legislature did everything, many things possible, and even though we have international laws and zero tolerance towards physical abuse, but still it is there, present in our everyday lives, as it seems. And the very same research also showed that 1 child out of 3 knew only that they have some special children's rights that should be protected. However, 2 out of 3 would not be ready to ask for help if they would feel that the rights are infringement. So this shows how important awareness and knowledge of one's rights is. And this already leads into the complaints mechanism that I want to reflect on in the following minutes. Actually, this is complaints mechanism towards human rights institutions, so not necessarily I will talk about cases before court, because that's not really my domain. I will rather talk about the fundamental human rights, so this right to complaint, the right to legal redress is a fundamental human right. The CRC guarantees this right too. So this mechanism is a tool that if the individuals and also groups can have the right to legal redress in such cases. So even if there is no ombudsman for children, which is an old pledge of our profession, and it's so excellent to see that in Poland, in a Central Europe, another Central European country, there is this institution of children's ombudsman. This is an excellent solution. This is to be strived for, because this means a stronger protection for the children's rights. So in this context, I will talk about this right to legal redress. Now, why is it so important? not only because it's a fundamental human right for children, but it is actually a fundamental dimension of children's access to justice. So this child-friendly jurisprudence and jurisdiction, for that it is an excellent example that children on their own rights can initiate legal redress. And this, of course, contributes to the recognition of children as full citizens and shapers of their own lives. And this is a very important message. So, and why is this so important, these complaints for the institutions? Well, on the one hand, because such complaints are essential sources of information about children's lives and problems. There can be researches going on and statistics and so on, but still the best sources of information are children themselves, because there are aspects that you just cannot find out from questionnaires, from researches and so on, because the priorities there are very often very different when it comes to decision making. And an excellent example is if we look at the messages by children on the walls outside in the foyer, and congratulations to the organizations, it's so excellent that they contributed to this conference too. So what the children regard as their important children's rights, and these are not necessarily the same that we would regard as their most important rights. So it's excellent, it's very important, essential source information, what they regard as key rights. Now, during COVID, from the governments concentrated on healthcare, on vaccines, and so on. But it is also important to deal with the mental health of children, how they suffered from lockdowns with no school, or only in the online sphere. But obviously the authorities did not reflect on this at the first time. The priority was on the urgent health care, on vaccination and so on. But the children's aspect is also not to be neglected. Now, for the institution of the Ombudsman, the complaint is not just a source, but it is also a key instrument for policy decisions and legislative changes, and it is also a base to communicate the work, its work and achievements. And do children have complaints? Do they really complain? Well, just as children are not aware of their own rights, exactly in connection with this, they also do not really complain. There is just a low proportion of children who complain. There's a lack of information and so on in this regard. So in general, on the whole, there is really a lack of information, not about one's rights and awareness, but also lack of information concerning if there is a problem, who I can turn to. As according to the experiences from international researchers, this also leads to why there are so few complaints by children. So we do know that the amount of complaints from children is really small. And it is also believed that complaints won't be taken seriously. So it is also important to listen to children, but that what they tell us should also be really taken into account. And this does not necessarily mean that we have to act absolutely in accordance with what the child said, but we should really listen to them actively with an open ear. And there is also a fear of punishment present. So this is a fear of negative consequences and retaliation. As a summary, what does it mean? So this complaint mechanism is not a Hungary-specific thing, but these are not sufficiently accessible to children, and these need to be made more child-friendly, and how can this be provided, child-friendliness? In 2016, there was a report published of the United Nations High Commissioner for Human Rights about access to justice for children. And it says that an independent, safe, effective, easily accessible and child-sensitive complaint and reporting mechanism should be established by law in compliance with international human rights norms and so on. So both aspects are important. Just that I mentioned, the researchers underpin this. So all the elements are important, and this also follows from the convention, because how can such a mechanism be made child-friendly? Well, if we understand it as a complex mechanism, this convention, then, well, of course, everyone under the age of 18 are regarded as minors, so the CRC applies to them. So the right to dignity, non-discrimination, or vulnerable groups, I will mention them. So there are some so-called invisible children, those with disabilities, those who belong to certain kinds of minorities. For example, Roma families, Roma refugee families from the Ukraine, and well, they should be there in the educational system, but are still invisible. So there are some groups who, besides being children, who are already vulnerable in themselves, but are extra vulnerable. So that's again a challenge. Now I could go on talking about this, how we could communicate with children well, how experts could be trained so that they have the expertise in dealing with children. There is an element connected to attitude. So there are physical and geographical problems sometimes, so that we have our center here in Budapest, but actually the issue affects the whole of Hungary. So geographical reach is also an issue, so securing availability and accessibility, and also there is the time factor, so procedures can last extremely long. So if you want, it's just like if you would want to explain to a 5-year-old that Christmas will just be patient, Santa Claus will come in a few days. Well, children are impatient, so they just have no grasp of time. If something is urgency is for this reason a key factor when it comes to any kind of access to justice. Okay, so for these institutions, so the Committee on Child Protection, so for the implementation, all these institutions are necessary. These should be supported. They should be independent. Now, I don't want to go into details concerning these, but what is important that there is an optional protocol 3 to the UN Convention on Rights of the Child, and the Committee on the Rights of the Child became competent that if there is an infringement of the rights of the child, then this committee can turn to the Commission, and this is really, really important. And this, it has already been mentioned today, that this convention is widely, broadly accepted and adopted, ratified internationally. And in these states, if there is an infringement, violation of the CRC, and there are no more possibilities for international redress, then they can turn to this commission. Most countries have signed this, some not, Hungary also not, even though the EU is the most successful in signing and ratifying this. So it's just United Kingdom and Sweden and some others who not, and Greece and Hungary who have never ratified it, but otherwise most countries in Europe did. Actually, the Committee on the Rights of the Child recommended to do this to adopt this optional protocol also. So it was recommended to Hungary already. And just to, as a closing remark, being patient for children is very difficult. And if we talk about climate change, maybe it's not surprising, but this triggered the active participation of children. Just think of the demonstration, all the protests going on, but the national platforms and forums and so on, where Europe-wide there are cases, court cases going on where children are participating too, and which are connected to climate change. And for example, there was also in October 2021 there was a milestone, so-called climate case, where 16 children and young human rights and climate activists petitioned the 5 states parties to the convention: Argentina, Brazil, France, Germany, and Turkey, the 5 largest emitters in the world. And it was important that there was a participation of children and the access to justice for children, securing this. And even though this was not recognized, but it was still very important for the communication of the committee, because actually they said that these countries did not everything in connection with the protection of the rights. So this is a whole new direction. Children regard this worldwide as an important issue, and this is something that is there in front of national courts, and not only with the child courts, but also if you think of the court in Strasbourg. Thank you very much for your attention. I think everybody knows that we have huge tasks in front of us. And thank you very much again for the organizations for everything, for the organizing of this conference. Thank you very much.
Distinguished speakers, ladies and gentlemen, it's an honor to stand here today in front of you, so many fantastic colleagues and professionals. And it's been a pleasure and very, very inspiring to listen to the presentations yesterday and today. And I truly hope that I can contribute to the success of this conference. My name is Dorina Csaller, and I work as a legal analyst at the National Media and Info Communications Authority at the Internet Hotline Unit I will talk about later. And the hotline unit is part of the Child Protection Department of the authority. My topic today is digital child protection and the digital rights of children. And I also would like to talk about the latest UN General Comment on the rights of the child, on the Convention on the Rights of the Child, and the relating child protection activities of the NMHH. To help you understand the importance of all these, please allow me to highlight some important data from the research completed by the NMHH in 2017 and in 2020. The proportion of children aged 7 to 8 owning a cell phone has nearly doubled. Among them, the proportion of children who are registered users on a social media platform has tripled from 3% to 10%. And this proportion even reaches 60% among when we examining 11 to 12-year-old children with own social media profiles. And on average, children register on social media platforms at the age of 11, so we can say that they are entering the digital world at a younger and younger age. And please note that there is a 13-year-old official age limit for registration on most social media platforms. And another data is that within 3 years, the proportion of cases when a stranger tried to contact 11 to 16-year-old teenagers has doubled. It has increased from 9% to 18 or 19%. And 1 out of 10 children accepts the friend request of a stranger, and almost a quarter of the 13 to 14-year-olds and almost a third of 15 to 16-year-old teenagers keep contact with the virtual friends, persons who they have never met in person. I think that alone these figures clearly indicate the fact and that we cannot forget the importance and the need to protect children online in the digital space. And in this context, it is essential to talk about digital children's rights. And these figures and data I have mentioned, they were taken from the research completed by the NMHH from 2017 and 2020. The authority conducted a big-scale representative national research with the involvement of 2,000 parents and their children. The research focuses on the media literacy and media use of children and their parents, and also focuses on the digital parenting strategies applied by parents at home. And it was a very important part of the research that it had particular focus on the risks and dangers children may encounter in the digital space. And one thing is certain, I think, that while the digital environment offers new opportunities for children's rights and for the realization of children's rights, it also poses the risks and the dangers and poses the risk of their violation and abuse. And this fact is also underlined in the latest UN General Comment on the UN Convention on the Rights of the Child. It was issued by the Committee on the Rights of the Child, and it was published in 2021. And in the midst of the pandemic, I will talk about later in more detail. The comment focuses on the children's digital rights and the child protection in the digital environment, and it describes how states concerned should implement and also enforce the Convention on the Rights of the Child in the digital environment based on the 4 key principles of the Convention. But why is it so important to have this document? The first thing is that it is clear, and we all know that the 1989 UN Convention on the Rights, by definition, it did not address digital children's rights, as these have not existed by then, of course. And so it was a very important step in 2021 to emphasize the protection of children online in this way. Another fact is that the internet and the technological developments have significantly changed the way children's rights are implemented. And another fact, that the pandemic, we know that has also contributed to this process very significantly, as the restrictions have pushed many areas into the online space, such as education, social life, and networking. And for this reason, children and youngsters were also nearly forced to go online. And the general comment, we know that it's non-binding, but it is nevertheless a valuable contribution, as it formally recognizes the importance of digital children's rights, and it recognizes that the rights of every child must be respected, protected, and fulfilled also in the digital environment. And now let's take a closer look at the the general comment. I'm going to list the children's rights that are included in the comment, and these are the rights that are most affected by the online space and can be well understood in the digital environment. And therefore, these rights require special attention and special protection. So here you can see access to information, freedom of expression, freedom of thought, conscience, and religion, freedom of association and peaceful assembly, right to privacy, birth registration and right to identity, right to education, right to culture, leisure, and play, right to protection from violence, economic, sexual, and other forms of exploitation. And in relation to the protection of children from violence, the comment states that children should be protected from abuse, exploitation, and all other acts and forms of violence in the online space as well. Because we know that the digital environment may open up new ways to perpetrate violence against children by facilitating situations and content in which children experience violence. And crises such as pandemics may lead to an increased risk of harm, and we know that children spend much more time online in these times. And moreover, it's very important that not only children, but also sex offenders, predators, and perpetrators have been pushed into the online space during the pandemic. And at this point, I would like to turn to the child protection activities of the NMHH, and let's look at how NMHH can help children and also parents. In February this year, the Department of Child Protection was established within the authority with the undisguised aim of paying special attention to the protection of children online. The Child Protection Department operates two independent units within the authority. One is the Media Literacy Unit, and the other one is the Internet Hotline Unit. I will talk about these later in more detail. The Internet Roundtable for Child Protection is a 21-member advisory board to the President of the NMHH, and this board forms opinions and recommendations for promoting child-friendly internet use, including the effective use of parental supervision and filtering softwares, and also improving the media awareness of children and parents alike. The Child on the Net website, it's also very important. It was created by the NMHH in 2020, and it helps parents understand their children's online behavior. It shows the dangers and the risk and harms, but also what and why children are enjoying in the online space. Its main aim to help parents to talk to their children about even those online questions that don't have easy answers. The next point is the Magic Valley Media Literacy Education Centers. The Media Literacy Unit is responsible for the operation of these centers, which currently operates in 3 cities across the country. The aim of these centers, in the spirit of prevention and awareness raising, is to provide visiting school classes with workshops on the opportunities and advantages of online space, as well as the dangers and risks and challenges. It is important that children are equipped with the right knowledge and skills to protect themselves in the online space and avoid harm and abuse online. And then, Internet Hotline. It is there to help if the problem has already occurred. The hotline is an online information and help or assistance service which is available for children, for parents, and practically for any users on the internet to report illegal content or content harmful to minors. The NMHH has been operating the Internet Hotline since 2011, And over these years, so in the last more than 11 years, Internet Hotline has handled more than 14,000 reports. The framework and the limits of the procedure of hotline are strictly regulated by the Electronic Communications Act. And according to this provision, the most important characteristic of the procedure is that Internet Hotline does not constitute an administrative or official procedure, and the hotline report cannot be considered as an official or an administrative action. But then, in what way is the hotline able to help? In this respect, Internet Hotline acts as a mediator. It primarily contacts the content provider or the hosting provider based on the hotline report, and the Internet Hotline asks or requests the examination of the reported content from the provider. Internet Hotline does not have the right to oblige anyone to delete or remove the allegedly illegal content. It can only ask. And these are the reporting categories of Internet Hotline. The online reports can be submitted to the hotline via web form or email in 8 reporting categories. Today, in connection with children, the most important categories are child pornography or child sexual abuse material category, the category of cyberbullying, and the category of content harmful to minors. And in this respect, it's important to know that since 2019, Internet Hotline has received most of the reports in the category of child pornography. These reports have concerned child sexual abuse materials, so-called CSAM, and upon receiving CSAM reports, these are examined by trained hotline analysts, and if necessary, these get forwarded to the most important cooperating partners of the Internet Hotline for further investigation or further action, namely the National Bureau of Investigation and the relevant member hotlines of In Hope, which is the International Association of Hotlines around the world. The pandemic has had a strong impact on the number of reports, especially in the category of child pornography. Please see here the exact numbers of reports, especially again the numbers of the reports in the category of child pornography. Reports from 2011, it was the year of the establishment of the Internet Hotline, and 2020 and 2021, the years marked by the COVID-19 pandemic. You can see the numbers. Last year, we get more than 4,000 reports in the category of child pornography. It was more than 70% of all reports. And this year, not the same, but very, very similar. The Internet Hotline aims to make these materials inaccessible as soon as possible in cooperation with the Domestic Law Enforcement Agency, as I have already mentioned, and other experts from the world and the other hotlines from the world. And it's very important that it is impossible to estimate how many millions or billions of child sexual exploitation, or how many millions or billions of images and videos of child sexual exploitation are currently circulating around the world. But it always must be remembered that these images and videos are made of real children suffering real abuse. So at Internet Hotline, every report counts because each image represents a new chance for a child to be freed from an abusive environment, and at the same time, also with the assistance of Internet hotlines around the world, the digital evidence of this abuse can be removed and can become inaccessible. And this is what keeps us going on this route at Internet Hotline at the National Media and Info Communications Authority. Thank you for your attention.
discuss about what is behind the protection, key issues of the capacity of the child to exercise their fundamental rights. Very good day to you, and I'm so happy that still so many of you are here. Yes, indeed, this is my topic that I would like to talk about today. Well, lunch is very near, that's good news. So, what do you need as a hors d'oeuvre? It should be something short and something excellent, something spicy. I won't talk about something, but rather highlight some problems, some specific aspects. So, actually, I will talk about the child's ability to exercise a fundamental right. Now, this seems as a frightening topic. Maybe it does not comply with what you might think of reading my title, but what I want to concentrate on is not my exclusive research, but it's the work of a whole working group from our university. So it's our common, these are the results of the common thinking of all of our working groups. So we have research going on about this ability to exercise a fundamental right, and I will just highlight one specific aspect of this. It's from the point of view of fundamental rights, and you can also see that the project itself is much more comprehensive. So, for example, it also deals with the rights of people living with disabilities and so on, or artificial intelligence and so on. So we also deal with that within our research. However, now I will, as I told you, concentrate on the exercise of fundamental rights. Usually, the very first thing is child protection. This we've heard through yesterday and today. So here everybody is on the same page. The protection of the child is important because children are vulnerable. They can be easily influenced. And this is why they should be protected. And why everything happens for the protection of the child. Nobody says that we do this in the interest of the parents. Everybody talks about protection of a child. But if we really want to protect the rights of the child, well, then whose duty it is and from whom should they be protected and why? So these questions trigger a lot of things. This is what you see on my slide. So it's whose competence to decide about the protection of the child, what aspects should be regarded that is it the parent, the state, somebody else? What about the parent's autonomy, the child's autonomy? Is there such at all? Is it important to what extent we regard someone as autonomous? Then the consequences, if you want to protect someone from somebody, then maybe that protection mechanism has much more severe consequences than we would think at the first sight. Does it fit into the realms of protection to protect the child from potential risks? So risks that are not yet present, but later on might be present. And it is difficult to answer such questions, and these might be even abstract questions. So this is why I brought to you an example. This is a right to gathering, and it's not. It's also. It's the right to gathering, and it's a question if children would like to protest, for example, for teachers' rights or concerning climate change, and or in any kind of relation, can the child demonstrate? Can they protest? And both parties will say, yeah, either yes they can, or yes or no they can't. They can say yes because this expression of democracy, participation, and democracy, standing up for one's rights. On the other hand, one can say that because of the protection of the child, no, they cannot, because they can be exploited for political reasons and so on. So you can decide for yourself where you are on this scale, at which end. However, it definitely poses questions. So this is an interesting question, whether children can participate in demonstrations and whether they can organize demonstrations. And if we want to investigate this, then the child as a subject, his interests shall be investigated. Of course, not you, but generally people tend to forget that there is also a subject of this protection, and it's not an object, but a subject of protection, that's the child. So the child is an active participant of this activity and not a passive subject. So, and these are no novelties, but it's good not to forget this. Now, let's see what would happen if the child had a real, full and complete ability to exercise a fundamental right. Now, this would be really harsh. I already tell you this. This would mean that the right to gathering, for example, that could directly exercise this without any external or influences, so without the influence or leading of the parents. So this would mean a real and complete ability to exercise the fundamental right, just like anyone else. And it's also important to mention that if concerning jurisprudence, there is a protest that will be prohibited and the police interacts, and can the child itself request redress? And we just heard about how important complaints are, because this also is in the realms of jurisdiction that the person should be able to exercise his or her rights to complaint and redress. So this belongs to all this complex. Well, the problem itself is basically that whereas the child is the subject of rights, at the same time, the child does not have the full autonomy of adults. Well, this is also in the CRC General Comment number 12 that defines this. So we are talking about a legal subject that we know precisely that children in this form are not capable to this. So how can we find solutions to this problem? Well, the first step would be that even would seem obvious to limit the rights of the child, this has to be reasoned. So we have to give arguments that with respect to this full ability to exercise a fundamental right, which is an idealistic one, obviously, but if we hinder the child, if we set conditions for the exercising of his rights, then we should be able to give arguments for this on the basis of the fundamental rights. But this in itself, even that would be not enough. So the capability of the child to exercise his rights, there are many components of it, and there are many things having impacting this. This you can read on the slide. So one is quite obvious. That's the child's maturity. Is the child capable of making a decision? So, for example, concerning the protest, the demonstration, does he know what it is about? Maybe if he plays an active role and tells a poem or whatever, does the child exactly know what consequences this might have? Is he or she enough mature for this? Now, it's again a very, very interesting question to investigate. And how can maturity be investigated in many countries, also in Hungary? So it's the state determining factors. So for example, if somebody is above a certain age, then automatically one is regarded as mature and has the full capacity to exercise rights. The other possibility is to look at the psychosociological setup of the child. Maybe the child is not 14 years old yet, but is still, from this respect, mature enough to make autonomous decisions and take responsibility, so is capable of exercising his or her rights. Now, concerning the right to gathering, the legislator could theoretically set such borders, such limits, but it is also possible that if the court would really investigate that the child as an organizer or maybe a participant of a demonstration, but rather as an organizer, would be really capable of exercising his own rights. Is that child really mature enough to do that? Well, it's really an important question about what fundamental rights we are talking about. Is it the right to free opinion, or right to free gathering, or concerning health interventions? So it's of course it makes a difference. So it's important to analyze possible consequences, risk, and so on. So if there is, we are talking about a protest, a demonstration against what it takes place, what the risk and could be. So the maturity of the child and the objects of the decisions together could determine the capacity to exercise one's rights. And of course, in case of children, we cannot forget that the rights or obligations or responsibility of parents, all three are present. So the rights, obligations, and responsibility. And we know that also from the CRC, we know, but also from Hungarian legislation, that education should be carried out in the best interest of the child. Yes, we've already heard about this, that what is the best interest, and it's again a terminological issue, what is the best interest, but we can say, okay, clear, but what is the best interest of the child in such a situation? So there is a general comment to the third article of the CRC where it's about the definition of the best interest of the child. However, it's on a higher level. It's not always easy to really implement this definition in concrete cases. So who can define what is the best interest of the child? It's the parent. The parent decides what is her best interest, whether he or she can participate and demonstrate, or should it rather be the state defining this, saying that in the case of the child, objectively, is it the best interest of the child to protest in a given topic, concerning an given topic, given age, and so on. And this right of the parent, the right to education, right to child upbringing, something that belongs to it. This is the taking account of the child's opinion, that concerning a certain decision, the child has to be listened to, and his standpoint has to be also taken into account. And in this case, the parent, well, has to regard this also when the parent makes a decision. And then the third aspect in this system that could be worth mentioning is that concerning let's talk about demonstration or gathering or even marriage or traffic safety and the public interest behind these could really stand for the argument that the capacity to exercise children's rights should be limited. So it could say that children should not be able to organize demonstrates because in the public interest, it's not really in the public interest. There is also terminology in the CRC that the children's gathering rights can be limited on the basis of public interest. Now, if we look at all these aspects, let's concentrate on the alternatives and all their consequences. It's really difficult to make decisions. It's also not our aim, it's rather food for thought. So first question, is it the free fundamental right of the child to exercise rights, for example, gathering, a right to gathering? And, well, the demonstration then should be announced before, but also there are some specific, there are no real specific further criteria. It's really a question whether the child can exercise his or her right. But what if the parent does not allow this? Because what if the parent says, no, you cannot go. You will not go to this protest, and locks the child up in the flat? So that what if the parent just prohibits the child from going to this protest because he says that it's not in the child's best interest? Well, this poses a question. It's not to be interpreted from the legal point of view. Does the state have a role to play in this case? But in the second case, if the parent decides in the framework of his or her rights that whether the child can go to the protest or not, can the state in such a case say that it's the optional decision of the parent? So the parent has the right to decide, so the state says nothing to this, so it's up to the parent to decide. And then a further situation is when the state prescribes. Now, concerning the right to gathering, this is not so, but concerning abortion, there must be a co-decision with the parent. So either or the parent decides instead of the child. So it's and makes a decision concerning whether the child can go to protest or not. And then there is a third case when the state says that it's the state will make a decision even instead of the parent, that in certain cases, for example, minors under the age of 14 cannot go to gatherings. It's prohibited. The situation is absolutely different. For example, in Russia, when the child was there at the demonstration, the parents were punished. Well, that's an extreme case. But what if the state does not let the parents decide on this issue, but generally places limits to this right of the child? So it's a question of the. Is it the intervention of the state legitimate? So is it really valid? So what a good parent is? So then is it really valid, such kind of a decision or limitation? And it's also an important question that no matter which alternative we choose, well, protests will anyway take place. The situation is there and continuing there, but it's worth thinking on the level of systems. And if we find an alternative, if we think about these issues, then also such aspects should be taken into account. What are the ways for legal redress? So if the parent or the state places limits on the exercise of his or her rights, then what he can do, what is his access to justice? Well, in this case, for example, there are limits also concerning court cases. So it's really worth thinking about all these issues. I promise to keep myself short. I hope it was not too spicy for you, and I hope I gave you food for thought, and now enjoy your lunch.